All right, I think we'll get started if at least, the very least, our panelists can be seated. Maybe the rest of you also. Good afternoon. Welcome to New America. I'm Mark Schmidt. I run the political reform program here, and I want to thank you for joining us for this event focused on the new book, Shadow Courts, the Tribunals that Rule Global Trade by Haley Sweetland Edwards, a fantastic book about investor-state dispute settlement. I guess before I introduce the speakers, I will say you might ask, why is the political reform program in New America putting on this event? And aside from the fact that we often get outside of our lane, I think it's a real indication that we're beginning to recognize that a lot of issues around trade, and particularly as they relate to the Trans-Pacific Partnership and other recent deals, they're actually as much about democracy and power and how decisions are made as they are about actual trade barriers. And I think that's the ISDS kind of reflects that in a very sharp and distinct way, so that we begin to think about, like, who actually makes these decisions about our own country's policies of other countries arrived at democratically, and then the interests of corporations, and how are those balanced, corporations and investors. And that's about the end of the limits of what I actually know about this topic. So I'll stop talking and turn it over first to the author, Haley Sweetland Edwards, who is a correspondent at Time, where she covers everything from education and healthcare policy to cybersecurity in the world of smart toasters. She is I should say she falls in that large category of people who are kind of friends of New America. We see her here a lot. She was on a panel here yesterday, but she was also an editor at the Washington Monthly, which is a magazine that we all have an affinity with, where she wrote some of the most amazing pieces I've ever read about regulation, regulatory structure, and really, again, the structure of democracy in the United States. She's also been a foreign correspondent in the Middle East and the former Soviet Union, and she is a graduate of Yale University and Columbia School of Journalism. After Haley presents the basic ideas of her book, Todd Tucker will comment, and then we'll have a dialogue between them before we open it up to the audience. Todd is a fellow at the Roosevelt Institute, where he leads their work on trade and foreign economic policy. He was, until pretty recently, a Gates Scholar at the University of Cambridge, and he's been research director for Public Citizen. His first book on fast track and congressional trade politics was launched here in a book talk in 2009, and yesterday Politico published his proposal for a rethink of investment rules as one of the agenda items in the first 100 days of the next administration. So this is a pretty high-powered pair to talk about this topic, and I'll just turn it over to Haley.
Well, thank you. Thank you, Mark, for that introduction. Thank you, Todd, for being here, and thank you to all of you for coming. It's a busy week for trade in Washington, so thank you, everyone, for coming out. I see a few people in the crowd who know quite a bit about ISDS, and other folks who I'm not sure what your knowledge base on this is. So I'll give you a brief, a short and dirty history of ISDS, and then, as Mark said, Todd will talk a little bit about the future going forward, and then we'll have questions. So, so that's the agenda for the evening. And I wanted to. The thing about, or the afternoon, the thing about ISDS that's kind of great right now is that we are experiencing a moment of ISDS in the sun. Investor-state dispute settlement is not something that you would ever expect to see on front pages and in headlines and in 18-month investigative pieces at BuzzFeed, but now is the time for that. We're seeing it come out. We're seeing people across the ideological spectrum talking about it publicly, raising concerns. On the left, we have Elizabeth Warren and Bernie Sanders, who have been very, very vocal about their concerns about it. And on the right, we have libertarians and traditional conservatives, the Tea Party conservatives and lawmakers on the Hill, very concerned about this as well. So this is not even remotely an ideological issue anymore, which is a very exciting time to be writing about it and talking about it and thinking about it. With that, brief history of investor rights, 2,000 years in 30 seconds. When 2,000 years ago, when people wanted to be merchants and investors abroad, they would cross out of their homeland, and all bets were off. They had no protections. There was there were no nation states, period, but there were also no governmental structures, no rule of law that they could rely on. If you loaded up your goat cart and headed off into foreign territory, you were on your own. And starting in about 300 years ago, in the Middle Ages, groups of merchants got together and began protecting each other. And slowly, you saw the rise of nation states. You saw these larger governmental structures that could protect, that could create monopolies on power within their own borders. And you saw merchants and investors begin to rely on the rule of law in these foreign powers to protect them as well. But this is really new. This is the last 300 years of history that we started seeing investors and merchants actually enjoy any sort of protection outside of their homeland. So starting about 300 years ago, we saw the beginning of this idea of arbitral tribunals. And it was as early as the American Revolutionary War. In the wake of that, you had folks from the British government, folks from the brand new American government sit down at a table and talk about not only how they were going to sort out their own governmental futures, but how they were going to figure out how to reimburse private citizens, farmers, sailors, merchants who had had their own property destroyed during the Revolutionary War. And that's what they were governments negotiating on behalf of private individuals and their private property. So again, major step, major change from what it was 100 years before that, and certainly 2,000 years before that. So this rise of arbitral tribunals, it's international arbitral tribunals, started about 300 years ago with the birth of our nation, and started cropping up beginning of the 20th century, started after the end of the US-Mexican War. It was a great example of an arbitral tribunal then, but it really wasn't until the 1950s. So my point here is to illustrate how dramatically new this is in the history of civilization. That in the 1950s, we saw the rise of investor-state dispute settlement as we see it now. And what makes this so special is that for the first time, it wasn't a country and another country sitting at a table together discussing the ways to reimburse their private citizens or private companies for any losses during a war or during any other conflict. Investor-state dispute settlement has an individual investor or corporation sit at the same table with a country. So that's what makes it different. And they, after the end of any conflict, after the end of any disagreement, any regulatory disagreement, then an individual investor can demand a binding arbitral tribunal with a sovereign nation. So that's the scope, that's the stretch that makes ISDS special, and something that's one of the reasons why it's so politically poignant right now. So to take a step back, 1959 is the first time that investor-state dispute settlement showed up in a bilateral investment treaty. It was between the United Kingdom and Pakistan. And it was, at the time, basically a gentleman's agreement. It said if Pakistan or if the UK, I mean, they're bilateral, but really if Pakistan behaves in such a way towards British investors that British investors feel that was unfair, they don't have to go through Pakistani courts. They can go to this arbitration tribunal. They can demand a binding arbitration with Pakistan. And at the time, kind of made sense why they wanted that treaty. I mean, if you were a British investor investing in Pakistan in 1959, you didn't really want to rely on their court system. I'm not even sure you really want to rely on their court system now. But that was the idea back then. And in the 60s, you saw bilateral investment treaties, including this ISDS provision, start popping up. You know, a dozen here, a dozen there. There were about 200 by the end of the 70s. And this was a period of rapid nationalization, of post-World War II national governments and communist regimes. There was a lot of expropriation, a lot of nationalization of domestic resources, things like that. So that was the foundation politically and internationally that gave rise to ISDS. The US was late to the game. We signed our first bilateral investment treaty with ISDS in the 1980s. And the whole idea behind that was the same that had driven the establishment of ISDS in the first place. And that was that Jimmy Carter in the late 70s was worried that basically American companies and investors would get into tussles with foreign nations, and that the US government would have to step in to back them up. He wanted to have a separate avenue, a separate forum to engage with, for companies and individual investors to engage directly with countries, so that the US wouldn't have to be involved. So I lay out this whole history because I think it's really important to understand where the heck this thing came from. Because then, now it seems a little bit insane, to be honest. Like
Technical term.
A technical term. And this gets to my story, where I got really interested in ISDS because I first read about it in some wonky trade article, and I thought that this can't be right. We can't. Why are we allowing private investors and private corporations to directly challenge the U.S. government outside of the U.S. court system? What gave rise to that, and why are we so enthusiastic about it? So then I started digging, and that's why I give this history first, because that's the reason for it. We were worried about communist regimes, we were worried about nationalist regimes, we were worried about these sorts of conflicts between private individuals and sovereign nations giving rise to hot conflicts abroad. We wanted to maintain the world peace. But that's not what happens anymore. So, 1950s, take you back one more time, and then we're stuck in the present, I promise. 1959, first investment treaty signed with ISDS. There were basically no claims for about 10 years. And one reason for that is because, as I said, these things were gentlemen's agreements. They said, we promise not to treat your investors or your foreign companies unfairly on our soil. And in turn, you'll come and bring your companies here. You'll invest in our soil. That was the agreement. And if you have a problem with it, yeah, sure, you can have this arbitral tribunal. That sounds great. But there was no infrastructure for how that would actually be set up. There were no rules on who would be appointed, how these arbitrators would be appointed, on where they would meet, what rules would govern how these discussions would unfold. It just didn't really exist until the 1950s and 1960s and then 1970s. You had international institutions established that ended up serving this purpose. So even through the 1970s, there weren't that many claims. From 1959, when the first treaty was signed, till about 2000, there were somewhere around 40 claims total, ever brought under ISDS. Then beginning in the 1950s, you all of a sudden saw that shoot through the roof. You all of a sudden saw private investors and corporations start bringing claims against foreign countries outside of their court system. Instead of once every 2 years, instead of once every, or twice a year, a couple years pass, another one, you saw them happening 4 times a year, 10 times a year. Last year, there were 70 claims. In the last 15 years, there have been about 600 claims. So first 40 years this was around, there were 40 claims. Last 15 years, there's been about 600 that we know about. So what we're seeing is an absolute explosion of the use of this tool. And this is where it gets really interesting to me, because we designed this tool with that history in mind of we want to provide protections for investors. We're worried about expropriation by communist regimes. We're worried about rickety judicial systems in unreliable countries. What we have now, and the way that this mechanism is being used now, is not about expropriation. It's not about the nationalization of resources. I mean, that's a very, very tiny percentage of these cases, of these claims. What they're about now are more often than not regulatory squabbles, basically. You have private investors and corporations who are going into other countries and saying, well, you raised my taxes, and I don't think that's treating me fairly, and as a result, that is basically an expropriation of what I imagine to be my future profits. Or by passing that environmental regulation, you limit the resources that I thought I would have access to, and that is a de facto expropriation of my investment in your country. So all of a sudden, the idea that you would actually be going in, and let me give you two solid examples. In the 1970s, use of ISDS. The UK and Sri Lanka had a bilateral investment treaty that a seafood company, a British seafood company, had a factory in Sri Lanka. It was destroyed by a Sri Lankan military raid. They were going after the rebels. They ended up destroying this factory. This British seafood company wanted to get paid back for their factory. So they demanded an arbitral tribunal through ISDS, and these three arbitrators determined that that factory was worth, whatever it was, $470,000, something like that. Then the government paid that out, and that was the end of story. Now, to give you an example from this year, the Keystone XL pipeline was going to be built by a Canadian company called TransCanada. And it is currently bringing an ISDS claim against the US on the grounds that President Obama's decision to cancel the Keystone XL pipeline in some way violated their rights under the investment chapter of the North American Free Trade Agreement, under the NAFTA. Those are just fundamentally different ideas. One is a questioning the sovereign decision, the decisions of a sovereign nation, the regulatory decisions, governmental decisions. And the other is actually talking about a physical asset. So that is the reason why I decided to write this book, because I wanted to basically figure out what we were talking about when we started talking about ISDS. And what I found was that so many of these paragraphs that are embedded in so many bilateral investment treaties now, I forgot to mention, when the first bilateral investment treaty was signed in 1959, and there were smattering more in the 60s and 70s, they began to explode in the 80s and 90s. And ISDS started being included in almost all multilateral free trade agreements like NAFTA and CAFTA and possibly the TPP and TTIP if they both are passed. And now ISDS is embedded in about 3,300 different agreements worldwide. So you just saw not only the number of claims shoot through the roof, but the number of instances in which it's usable shoot through the roof as well. And now all of these things are litigatable, basically. What's fair? What does it mean when your ISDS clause says that your country has to treat this investor fairly, or that you're not allowed to behave in an arbitrary way towards that investor? or you have to in some way enshrine their legitimate expectations of their investment in your country. What exactly do those words mean? So a lot of the book is an attempt to trace the rise of that change in ISDS from where it was in the 1950s and 60s to where it is now. And I will leave it at that because that brings us up to the future. And I know that Todd has some great ideas of where he thinks that this should go next, and how to fix the system that we have now.
Great. Well, thanks so much, and thanks. It's so great to be back here at New America. As Mark mentioned, Lori Wallach and I launched our book here in 2009 with Barry Lynn. And it was a fantastic opportunity, and I love so much of the research that folks here at New America do, so it's great to be here. First, let me just make the pitch for the book. You should buy it. They're selling it out there. It's an excellent reference book. It's an excellent story, really putting narrative on what a lot of us have struggled with years, sort of using the technical jargon and sort of the legislative maneuvering. You've actually gone all across the world doing original reporting, and making this into something that sort of everyday folks can better wrap their head around. And there's really an embarrassment of riches right now of the investigative journalism that's going on in this space. Years ago, we really struggled to get anyone to even pay any attention to this obscure legal regime. And now it's the subject of John Oliver programs, it's on BuzzFeed, it's on Huffington Post. There's really, I think we're cultivating sort of a great crop of which Haley is a prime example of reporters that can actually contextualize this for the general public, and I think it's great, and the book is a great example of that. I wanted to start out just with some questions that I think shadow courts raises for sort of the general policy discussion, and some of the questions that the reporting raises is also as well some of the other fine work that I mentioned. First, sort of what is the cause for the enormous gulf between sort of ISDS insiders and ISDS critics, on the other hand? I don't know if you experienced this while reporting the book, but ISDS is the kind of thing that fails the grandma test. You kind of go out there and you say, hey, grandma, there's a case against the U.S. being heard outside of U.S. courts. There's a lot of fright there. It fails sort of the basic person on the street test. Greenberg, Quinlan, Rosner did research on this topic, and they found that, interestingly, the base of the Democratic Party is fairly pro-free trade, but nothing turns them into opponents of free trade quicker than just describing basic aspects of how ISDS works. However, I think if you go and talk, you were at the State Department earlier this week, if you go and you sort of make some of the same arguments around specialists, they find it not particularly controversial. If the outrage is cases being heard outside of U.S. courts, they would say, hey, that's true of international courts more generally. If the outrage is that these cases are heard not by judges but by arbitrators, they can point out, as you mentioned in your book, rightfully so, that this is, the use of arbitrators is something that goes back to the 19th century and even before. If it's that these tribunals don't follow precedent, that's another thing that's generally true of international law. If the outrage is that the rulings are binding on the government, that's true of treaties generally. You can kind of go down the list, and the things that to the general audience sound atrocious are in fact things that they say, go back and are very storied parts of international law. So, in short, you see when specialists see the folks rocking against the TPP in San Francisco and elsewhere, they see folks objecting to international law per se. Now, I don't think that that's correct. I don't think that's a correct assessment of the argument, but I think it does show that there's a big gap between the kinds of controversies that you point out and sort of what people on the inside take as sort of par for the course. So what is unique about this system as compared with other aspects of international law? I'd like to offer one hypothesis for what I think makes the system ripe for targeting, even by folks that are supportive of international law more generally. And I think it's the involvement of questionable companies with questionable incentives when it comes to litigation. So we know that companies, especially multinational investors, aren't always angels. We know that companies are often litigious. We know that some major companies are not angelic at all. You can look no further than the company run by one of the presidential candidates to see that that is in fact true. But I think what some critics find difficult to stomach in ISDS is the asymmetry of it. So on the one hand, you have companies with hedge fund backing with one-way exclusive rights to sue governments. On the other, you have understaffed, underskilled developing country governments facing million and billion-dollar claims. This creates a tilted bargaining environment even before you get to the actual tribunal, and where the fear is that countries will preemptively settle. And we have Luis Parada in the audience who knows some of that asymmetry as much as anyone. He worked with El Salvador and defending some of the cases that they're reported, and Haley's and other reporting. So as this reporting teaches us, flawed settlements are real. This is a real shame, because the available evidence suggests that in cases that go all the way through, countries win a lot. Luis can talk about that, and companies rarely get anywhere close to their total claims. So what can we do to ensure that countries don't make these ruinous settlements? One answer, which I offered up in this week's Politico, is to fix the remedies. So if there were not a possibility of a massive payday over regulatory changes, then it would not make economic sense for companies or for hedge funds to bankroll abusive cases. By my back-of-the-envelope estimates, we have about 120 cases where there's full data, where we know sort of what companies have spent on lawyers, what settlements they got through 2015. So interestingly, of these claims, companies only won 45% of that total universe. They only got 25% of their total claim dollar damages. So if you look, so in that respect, that looks not bad for states. But if you look at the chunk of the legal costs that hedge funds could have bankrolled, and then you look at the amount of money that the companies were awarded, you have legal expenses of about $800 million, but the damage payout was $56 billion. So relative to the status quo ante, where these companies had no money, whatever had happened with them, between them and the government had already happened, this is a return of over 900%. So even when you lose most of the time, it still makes sense on average to bet on the outcome of the claim. So that's sort of where we are now. On the other hand, if there was, imagine sort of a different scenario. Because this system, from the perspective of the individual investor, doesn't make a lot of sense. If you're getting pennies on the dollar for your claim, then the individual investor, especially if they're not operating all over the world, this is like a one-shot thing for them. They try an ISDS case and they lose. Well, they're in a bad situation, but sort of the hedge funds or law firms that work across the universe of cases do pretty well. So this is kind of a form of rent seeking. Well, so how could you have a system that would do better by sort of all parties, right? Where you wouldn't need this sort of extensive litigation. I mean, that's the funny thing. Sort of the reason for arbitration domestically or internationally is supposedly that it's so quick and so low cost. But a lot of these claims are going on for 10 years.
The average 7 years or something?
Yeah, it's very long. So this is you have a lot of folks that are getting billable hours while this is going on, but not necessarily great outcomes for state or investors, and particularly not very predictable outcomes for states or investors. So the proposal that I lay out in Politico is just, it's simple. Have a new convention at the international level where the worst forms of taking of property, expropriations, which as far as I can tell in 15 years of working on this issue, I've never heard anyone make a defense in favor of uncompensated expropriations. Maybe that's out there, but I haven't heard it, critics or proponents. So create a new system where the companies aren't having to pay the lawyers by the hour. Let's have a team of accountants round up what the country owes in the worst forms of expropriation, hand the state the bill, they pay. If the state wants to contest it, fine. They can request the arbitration. And that sort of rectifies a problem that's in the system now where, as you pointed out, countries sign these treaties maybe decades ago, have no idea sort of what the stock of potential litigation coming their way could be. In this case, if the state thinks that there needs to be a legal clarification, that puts the state in the driver's seat to determine. Otherwise, the investor can go home with their bill if, in fact, if in fact there was an expropriation. If there's not, and the company was just making things up, or in fact still had a lot of assets, a lot of value in its assets, then the company has to pay for the whole process. So I think that's a way to sort of right-size some of the incentives in the litigation. And, and I think as the stories by Chris and by you point out, a lot of the problem with ISDS isn't so much the cases that go to arbitration, it's what happens before arbitration. It's what happens with the threat of litigation. So if you remove any kind of credible threat for a massive outsized payday at the end of the day, then you're changing the incentives dramatically for all parties involved, and a country, a company could incredibly threaten a country with some sort of ruinous settlement. That doesn't mean that you would have to eliminate all international legal proceedings. That doesn't mean that there wouldn't be some role for arbitrators to continue to develop global standards. But I think for everything other than expropriation, you would create a different track where there would be advisory opinions. So just in the same way that a company can ask for an advisory, in this proposal, a company could ask for an advisory opinion about whether a capital control violated the state's obligation. I say, let's extend that advisory opinion process to everybody and actually lead to a proliferation of progressive international law. Let's have human rights groups be able to ask for an advisory opinion. Let's have labor unions be able to ask for an advisory opinion. And what that does now, and what that would do, is, one of the arguments for arbitration is that this helps promote good governance in developing countries. Rule of law, good administrative procedures. But right now you have a system where it's actually not creating good governance, it's creating an incentive for countries to govern badly and then pay for it afterwards. So if we actually want to push a good governance agenda, let's lay out what countries could be doing differently in domestic governance. So not breaching to pay, not paying to breach, but instead grappling directly with the tribunal and sort of saying, well, if we did this differently, would that matter? If we did this differently, would that matter? But then across not just a narrow band of investor rights, but across a broader range of public interest. Just sort of in the interest of moving on to some back and forth, I think another aspect of reform that needs attention, we don't have a lot of precedents in history where there is a system that gets controversial about 50 years after it proliferated so massively. In short of war, we don't have a lot of instances of a lot of treaties being fundamentally rethought decades after the fact. But this is a case where you had a lot of sleeper potential in the treaties that are now only being realized. So how do you go about doing this? Well, the approach that we've had up until now is that every few years, when an administration gets in the hot seat and there's some public outrage about the thing, they create an advisory committee at the State Department where they say, well, what could we tinker with at the margin to basically preserve the system intact, but move things around just a little bit. Some of those reforms can produce useful food for thought. But what they can't do is fix all of the existing stock of treaties. So I think that this is something that the next administration should be looking at seriously, is creating a mechanism to upgrade the entire network of past treaties with these sort of new principles of efficiency and fairness in mind. I think that this is something you could begin the process of in the first 100 days of the next administration, and both sides, Trump and Clinton, have critiqued the system. Clinton's called for a new paradigm. So let's have a change to, already, and this is sort of maybe something we can talk about a little bit more in the Q&A. There's, every 5 or 10 years, there's sort of a trend in academia or among public intellectuals where we sort of claim the state has disappeared. Sometimes it happens on the left, sometimes it happens on the right. You have the left sort of saying multinational companies have replaced governments. On the right, you sort of have the UN is shredding our sovereignty. It's never true. You always sort of see a resurgence of the state. You see a demonstration, whether it's, you could look at Putin's Russia, Chavez's Venezuela, or even just day-to-day regulation here in the US. Regulation happens, states can do it, they do it in the shadow of the law, but the power and authority ultimately still rest with states. You know, and that's also true of ISDS. The power, you know, you have companies threatening governments because of the shadow of the international tribunals. You have international tribunals producing opinions in the shadow of enforcement in the national court system. So what makes this stuff so powerful, and this is going back to the 1925 Federal Arbitration Act and updates that have happened over the years, what makes the system powerful is that our own courts say that we're not going to review the merits of these decisions, and we're going to help companies get the assets that the arbitral tribunals say they're owed. This is the foot in the hand and the purse of the state right here. You know, not disappeared. It's right there. And under our own national law, we could fix that. We could create a process where folks that are affected by arbitration decisions could vacate that award. And it wouldn't necessarily have to be limited to US cases. It could also involve cases with third countries, cases between France and Argentina. There's a lot of different, it could apply globally. And that can be the stick that we use to bring other countries to the table, which shouldn't be hard because, by the way, the US is the primary proponent of a lot of this stuff, to have a new convention that supersedes the stock of 3,200 different agreements that are already out there. I think that is it easy? No. Is it possible? Yes. And I think that that is, you know, and there's a lot of different ideas for reform, you know, all the way from libertarian folks all the way to the left and the right. There's a lot of alternatives out there, and I think that that is something important to keep in mind. You know, ever since Margaret Thatcher, there is no alternative. Like, there has been this attitude that we're going to always be playing defense against this thing, against this agenda that sort of moves forward inexorably.
Right.
I don't think it has to be that way. There are plenty of alternatives, and you know, I'm happy to talk about other ones that are out there as well.
Yeah, and I would love to ask you about some of them. I was sort of taking notes as you were talking. You started off saying that this fails the grandma test, which I think is a good way of putting it, because you tell people, or, you know, in that the poll as well, as soon as you find out that there is this supranational arbitral tribunal that no one's ever heard about, that allows foreign companies and investors to challenge our regulations and laws, it kind of, you go like, what? That doesn't sound right. But I actually think that you undersell that a little bit. Like, you're right that the internet is full, it just proliferates with, you know, mythbusters about why people are wrong about ISDS. But that it also, all of those things miss this point, that it is kind of shocking. And it is kind of unprecedented in a really important way. And it isn't just that, you know, all law is mushy and all international law makes domestic law subservient on some level. We're talking about something different, because we're not talking about nations and nations sitting at the same table. We're talking about private actors and nations sitting at a table completely outside any sort of national judicial edifice. And that's different. It's just different. That doesn't exist in any other realm. It's totally unprecedented. And I'll get to the human rights court thing in just a second. And this isn't just grandmas who are shocked by that. And we'll get back to some of the other stuff here. But when John Roberts, Chief Justice of the US Supreme Court, first wrote about this in a decision, he evinced this kind of shock as well. It isn't just me who's learning about this in some wonky trade journal and being overcome with disbelief. And it isn't just my grandma who thinks that sounds kind of fishy. It's that John Roberts read this and said, wait, this allows a foreign corporation or a foreign investor at any time, as long as their home country or a country in which they have a subsidiary has an agreement with the United States that includes ISDS. They can use this to invoke this arbitral tribunal to challenge anything that they believe to be unfair. Anything at all. They can lose those cases. And in the case of the United States, you know, our State Department is robust enough, our budget is robust enough to handle, you know, being challenged in those ways. But what about little countries? What about El Salvador? What about these, like, all of these countries that the mere fact of challenging them outside of their court system and putting in the hands of 3 private individuals the full power of that nation's purse is extraordinary. And you're right that people inside the institution don't see it as extraordinary anymore, but I think that that's a failure of imagination. And I think it's a little bit of the frog getting cooked in the water, where it slowly warms up and you fail to notice that you're in fact in a pot of boiling water. And another thing that I think that is, I just wanted to comment on, and then I want to ask you a few questions, is we are in such an interesting moment right now. And both Todd and I were kind of touching on this in our comments, that neither one of us wanted to be like, all international law is bad. And I would have, and I feel like that's almost like I want to start every talk by saying, like, look, we live in a globalized world. We live in a world in which goods and services must trade over our borders, and we need to be economically dependent on each other, and we need to be culturally dependent on each other in really important ways. We just need to be smart about those ways. There are going to be supply chains out there that we're going to be relying on other countries. We just need to be smart about which supply chains go to which countries. And I think that what we're witnessing now is just like a really interesting moment of, it's like almost this ideological fissure that's going on, where it used to be 25 years ago that Republicans were in favor of all free trade deals, and Democrats were opposed to all of them. But now, as free trade deals have gotten more and more complicated and now include things like ISDS in them, and include all of these, anti-child labor clauses and environmental clauses and all of these other things, you have both sides of the aisle sort of splitting off and wondering what the heck they're getting into. So that goes off point for a moment, but I think that one of the reasons that makes this issue so important right now is that we actually are talking about where the rubber hits the road in trade agreements and in investment treaties. So what Todd is talking about and how we actually create a system that functions and works for not only hedge funds and those betting on these cases, but actually works to do what this is intended to do is just a very important point. So with that, I actually wanted to hear a little bit more about, you mentioned the power of ISDS is powerful because it needs to be enforced by national courts. So how does that work?
So under conventions that we signed in the 1950s and 60s, the U.S. agrees to put its courts at the disposal of folks with arbitration claims internationally. So for many years, that was a contract dispute between a French boat and a Italian steel company, and then maybe one of the companies had assets here in the U.S. So the process would be wherever the location of the arbitration was, the winning company would go and seek to have the award enforced and recognized in that national court, and then they would go on a treasure hunt globally to figure out where the assets of the offending company were located. As it happens, there's a handful of places where sovereigns like to stash their assets. It's the financial markets of the world. It's the leading financial centers. So it's the U.S. It's London. So for many years, this was a relatively uncontroversial thing, and there was pressure for many years to remove as many cases as possible from the overcrowded judicial dockets. So if two companies could agree to a different set of rules, and then courts had to do very little except say, yes, you can seize that factory here in the U.S. as payment. It worked fairly flawlessly. When sovereigns got involved, it creates a trickier set of public interest concerns. So the former ambassador from Argentina, Cecilia Najon, is here, and she can tell you about maybe having to leave the embassy and kind of lock the doors extra well. When Argentina was subject to so many of the investment claims. So it is, you have hedge funds with a lot of resources that sometimes aren't even the original investor themselves. They've bought up the arbitration claim after it was rendered by a tribunal, and then, for very little money, can then go seek to enforce it and demand cash payment. So there's a lot of financial incentives in the system, and our courts have basically made themselves at the disposal of such investors. And as you pointed out, and here's sort of part of, I think, the an intellectual challenge of this space. John Roberts, the great quote that you report in your book, he was in the minority. In fact, he was the only one willing to write anything down criticizing this. This was a case between a UK investor and Argentina. It had appeared that under the treaty, the UK investor should have litigated or arbitrated their dispute with Argentina informally first in local courts and local administrative procedure before jumping to arbitration. This isn't some obscure dispute over the merits of what Argentina did or didn't do. It was just that the investor didn't comply with the basic rules for what they needed to do before launching one of these cases, which it's very minimal what they have to do in most cases before launching a case. So John Roberts points out, well, this seems screwy. We're supposed to be, I get that we want to defer to the arbitration decision, but if the arbitrators weren't even interpreting basic threshold aspects of the treaty in accordance with sound law, sound logic, then courts should have a role. But he was the only one that said that. The liberals and conservatives on the court had, and Breyer wrote a book about this where he sort of celebrates the virtues of the investor-state dispute settlement. And in his opinion, in that case,
well, he doesn't really celebrate the virtues of investor-state dispute settlement. That's a little bit of an overstatement. He celebrates the virtues of international law.
Yep. And up until now, I think liberal law scholars have tended to see this as an extension of the Cosmopolitan project.
But that's my point, and that's my point about why this fails. Not only the Graham test, but the John Roberts test. Is that in my opinion, this is not just an international court. It's not institutional because it's not pitting sovereign nations against sovereign nations. There's no appellate mechanism here. Mm-hmm. There's no body of jurisprudence. What we have is an arbitral tribunal. It's a private ad hoc tribunal that pits private investors against sovereign nations with no appellate mechanism and no institutional structure whatsoever. And that's what makes it different. And I think that's what John Roberts was reacting to. Mm-hmm. And I read Breyer's book and actually scoured it for mentions of ISDS because I was thinking, that would be great if he at some point weighs in on this. But I think this kind of gets to my comment before. The reason why we're having this tussle right now is because international law is different than this investment law that is being formed in this back channel sort of way through these private arbitral tribunals. Is that you're nodding, but I suspect you don't agree with me.
Well, I think that this is the gap that we have to overcome. Mm-hmm. Critics have passed the Graham test with flying colors. I think they've passed most of the Latin America popular opinion test with flying colors as well, and increasingly U.S. popular opinion. I think that what I see as sort of the next step of this as we get into the next administration is convincing some of those folks that, fancy themselves liberal cosmopolitans, that this is also something that needs a second look. Because I think that as long as you can't get at least a handful of people at the State Department to sort of agree with some of the assessment, it is hard to promote policy change.
And your solution that you lay out in Politico yesterday, it was published yesterday, it's a great article, it's outside by the way, if you didn't pick it up already. A really thoughtful analysis on the future of this mechanism on the global stage. And you alluded before to a couple solutions that people are talking about. But just to give you an outline, libertarians often go for let's scrap it entirely and have a free market solution, which means that if you are a foreign company and you want to go invest in Argentina, then you just decide you can take out political risk insurance if you want. And their argument is that the market that doesn't exist now will rise up to serve that need, should it arise. So that's one side of it. Then you have the kind of the liberal side that says get rid of it entirely and don't replace it with anything else. After all, as it is now, labor groups and environmentalists don't have any special court that they can go to. just put corporations in the same group as environmentalists. Put corporations and investors in the same group as public health advocates. No one else gets a special court, why should they? That's their argument. And the European solution, sort of this third body, and that's in between, is the investment court system, ICS, that takes ISDS as it exists now and basically puts it in more of an institutional structure. There would be more permanent arbitrators, although they wouldn't be entirely permanent. There would be an appellate system, as I understand it, and it would still feature many of the same aspects of ISDS. It would still only allow corporations to challenge sovereign nations and no other actors, so no environmentalists or public health advocates or human rights. Victims of human rights abuses. No one else can use this court strictly for corporations and investors. But it would have these backstops. So those are the three solutions that exist right now on the global stage, or that are bandied about at conferences and things like that. So Todd's contribution in this Politico article actually takes it in a different direction, sort of advances the conversation. So if you haven't checked it out, do. Last plug. But that, I guess my question there is, what you're trying to do or what you suggest doing is a little bit of a keeping one foot in both sides. You kind of want to create an institution, or you actually want to start from the ground up and renegotiate or rewrite some of these rules.
I think the proposal is about rewriting the rules, and it's about recognizing that some of these rules are very deeply entrenched, and that's why I went through some of the how a State Department person might look at some of these things. Mm-hmm. When you've had since the Treaty of Versailles the notion that lost expected profits can be compensated, this has become a notion in international law that's incredibly hard to shake. And lawyers trained at the best international law schools take this as a matter of course. Well, of course, we do that in our domestic tort system. Why wouldn't we do that at the international level as well? I'm not saying it's a good idea, but it's very deeply entrenched. So you have to be very clear that what you're targeting is actually a full-scale rewriting of the rules in order to make it clear that that's sort of the stakes of what we're doing. The way I sort of think about these competing proposals, it's yes and. I mean, let's see what works. All of these have some merits. Of the ones you mentioned, I think the one that I'm probably most skeptical of is the European Investment Court proposal. I don't know that there's sort of a tension in international law as opposed to domestic law where more secure tenure is not always a good thing. More insulation from political forces at the international level is not always a good thing. So, at the WTO, we have tenured appellate body judges. They've managed to produce some decisions that are pretty screwy from a public interest perspective. The tenure aspect, I don't think, is one that is, that's the main difference, right? As you pointed out, they're not talking about really changing the substantive rules in any major way. Mm-hmm. They're talking about creating an appellate review procedure. And again, that's something that fails the grandma test. There's no appellate review, there's no precedent, oh my God. That's actually true of a lot of international law. And I think and that's not a defense or an advocacy for that position, it's just a fact. So, I think that we have to be realistic about what we can expect international law to do. Mm-hmm. And I think that at its best, it's shining a spotlight on good practices and naming and shaming the bad practices. And then allowing the rest of us, as citizens of functioning democracies with three branches, to advocate domestically for what we see as the right balance between democracy and property rights. I think that so bringing arbitrators into closer dialogue and having it be not just on investment rights, I think is one way to have, reporters like you have fodder for the next 20, 30 years to be able to report about, hey, this idea is being floated, that fair and equitable treatment means good administrative practice. What do we think about that? Let's debate. Let's have Congress look at it. Let's have courts be able to review some of these decisions. Mm-hmm. I think that, and this is sort of, Anne Marie Slaughter, the head of New America, this is sort of her big thing about global courts. having sort of denser social networks where we communicate across countries about the values and virtues that we hope to promote in a global economy is a really good thing. Putting a huge cash payout at the end of that for adventurous companies, not such a good thing, and I think has led to a lot of the abuses that you highlight.
Right, right, and I would just underscore what you just said, that like so much of international law, or all of international law, is built on the building blocks of nation states. They're nation states coming together and agreeing on rules, and that's tricky. All rules are tricky. Anyone who's ever argued a board game with my brother knows that rules are tricky. But this uses different building blocks. This doesn't, instead of using nation states as building blocks, it allows corporations to be building blocks. It's corporations and sovereign nations, and I'm going to become a broken record here, on the same playing field. And so what's to stop? Why would that be our structure of this international law that we're creating? I guess that's my issue, and that's why I am suspicious of, or that's why I'm so insistent that this is unprecedented. Mm-hmm. Because we don't have, even if we don't have, appellate mechanisms in all of our international courts, and even if we don't have established jurisprudence in many European courts, I mean, that's also a very American idea, that we should have things that we can look back on and say, this is referential to all of this jurisprudence. It's very American. But even then, we have nation states going against nation states. So it creates this agreed upon backdrop. I mean, why shouldn't we have a court in which it's sovereign nations and all environmental organizations? Should we have Greenpeace be allowed to demand a binding arbitration with the United States government?
Any representatives from Greenpeace in the audience?
That's the idea that we're talking about here, though. Should we have AFL-CIO demand a binding arbitration with the U.S. government? Because
yes. Can I get a yes in the back?
Because those organizations don't have access to that mechanism.
Yeah. Should we take some questions from
Yes.
the audience?
That would be great, actually.
So we have mics that are going around, and I'll be calling on folks, so please raise your hand. We'd love it if you could identify yourself and then have a question or a short comment that can help move our discussion forward. So Cheyenne's in the back. And we had a question, Luis, I think, here in the front.
Thank you. Good afternoon. My name is Luis Parada, and actually I would like to see if you can expand on something you talked about, which is the composition of these international tribunals that decide investor-state cases. Because the most shocking thing to me as a practitioner in investor-state arbitration is that I can be appearing in one case as an advocate for a claimant or for a respondent, and then in another case I could be an arbitrator myself. And that, I think, is the most problematic conflict of interest that there can be, that there's not a requirement for the arbitrators not to also be appearing in other cases to argue similar legal issues that then they will be deciding later, or it creates an incentive for arbitrators who will act as claimants, for example, as advocates for claimants in another case, to rule one way that will go in their way. And I think that's probably one of the most problematic aspects of the composition of these tribunals, which having a permanent court at least would address that part. So that's one thing that I would like you to say a little bit more about. But also, I just don't think it is a fair comparison to say the investment court is one alternative to nothing at all or something, because I think the investment court only addresses one or two aspects of the overall big problem. And the big problem in the investor-state arbitration world is not just structural, it's also in the treaties, in this web of treaties that are, like you said, decades old, and it will really need a lot of untangling of that web before all the abuses that have been allowed to permit to go forward. And what really scares me is that the US government says that they have already found answer to everything in the investment chapter of TPP. But when I look at it, it looks very remarkably similar to CAFTA, which I have a lot of experience litigating. And I'm not a bitter person. You know, we have won both of our CAFTA cases. So, but I have seen how Guatemala loses two CAFTA cases on issues of treaty interpretation that are still vague in TPP. And why did not we take advantage of what we have learned in the way that the lawyers for claimants, because let's be honest here, lawyers for claimants always want to win this case that they have. They don't have any interest in the long-term viability of a treaty, so they don't care if they have to open a door that is 10 feet wide, as long as they win, whereas the state has an interest for the long-term viability, so we have double interest. So I guess my second point is that there's a lot more than just having addressing the issue of the composition of the tribunal, because I think there's also structural things with the treaties, and the states being the masters of the treaties, it is very appalling to me that they have not taken action to actually exercise the power to correct their treaties.
And if I could just take the prerogative here, I mean, of following up that with a question to you, I mean, one of the real contributions of shadow courts is that you go out there and you talk to so many people, including a lot of folks that kind of go through a personal transformation that you're able to document over the course of the book. You know, activist in Nebraska that didn't realize that Keystone Pipeline was going to become this huge international legal scuffle. Talk about June Klebe, I believe, who was someone that was kind of awakened to the system. You talk about the Attorney General from Argentina, who, you know, was a domestic lawyer and judge, who then gets brought in as the Attorney General to litigate the cases and sort of undergoes this awakening. When you're out there talking to folks, is this aspect sort of the thing that's most controversial, or what do you think is sort of the real animating principle that is sort of turning, you know, getting folks off their couch and sort of really eager to advocate around this?
Well, yeah, a sort of roundabout question. I will get to yours, Luis. I quote Jane Klebe in the book, and she's an environmental activist who spent years and years, about 6 years of her life, advocating against the Keystone XL pipeline. And you can disagree or agree with the Obama administration's decision on that one. That's not really the question at hand. In the wake of, so November 2015, the Obama administration nixed the project. January 2016, the TransCanada filed a ISDS claim against the United States, saying that that decision was a violation of the investor rights under NAFTA. So that's the timeline there. And I think that from Jane Klebe's perspective, she was basically like, what? Like, what courthouse do I show up in front of? You know, she had spent 6 years following this process, going from petitioning and going door to door to her neighbors in Nebraska, going through every different local, domestic, democratic process here in America, to all of a sudden realizing that this decision, or whether the U.S. eventually has to pay out an undisclosed amount of money to this company that had intended to build here in the U.S., was out of her hands. There was no courthouse that she could show up to. There was no judicial process through which she could file an amicus brief. She just felt completely disenfranchised from her own government's process or political process in agreeing or disagreeing to build this project because it happened to have been funded and underwritten by a foreign company. And that, as a brief aside, is actually a really interesting point in today's day and age, in today's economy. That the fact that TransCanada is a Canadian company is completely arbitrary. It could just have easily have been an American company, and then it would not have had access to this special judicial avenue. So to get to Luis's point, I mean, one of the questions that people were very, very interested in, and a question that I get asked regularly is how these arbitrators are appointed. What are the conflict of interest rules? How do those play out? And the simple answer is that the corporate or the investor gets to appoint one player, and the sovereign nation gets to appoint the second. And depending on the rules, if it's the ICSID, which is under the World Bank, then they'll either agree on a third, or a third party, like the president of the World Bank, will appoint a third. And the other short answer is that there aren't very precise conflict of interest rules. It really comes down to people determining that they, recusing themselves. And that doesn't happen in a lot of situations. It also requires that their fellow arbitrators have to rally to push them out. And these are very small communities of arbitrators. These people are friends. I forget the exact statistics, and I actually quoted Todd in my book on this section, so he should be the one talking about this. But it's a very tight-knit community. Everyone knows each other, or at least knows of each other. And the arbitrators that I spoke with, would refer to me actively, refer to each other by first name. And so the idea that you would have a self-policing crowd is just very unlikely. But I actually want Todd to talk a little bit more about that and what he sees as the problems there, because you did a lot of work on it.
Yeah, so I just finished up a 4-year project where I went around and interviewed an arbitrator from almost every finalized case to try to understand better. We have good portraits of how Supreme Court justices work together. We have decent portraits of the US district courts, but we don't know a lot about how arbitrators work together. So this was the topic of the dissertation and topic of a manuscript project that I'm working on now. I think on the one hand, judges everywhere like country clubs, and there is a tight-knit judicial community, whether that's in El Salvador or the US or the US Supreme Court. I mean, it is a tight-knit, in the political science literature, we would say epistemic community of like-minded folks. I think that what does make the system different is sort of the fairly blatant way. I mean, I think this happens, domestically as well, that, sort of, if you're well-liked within the legal profession, you have a better chance of elevating to sort of top judicial post. But I think what's different here is that that's also the formal mechanism, in a sense, is that you're nominated by folks that you've worked with in the past. And what arbitrators told me is that the kind of decision you get from the case depends wholly on the 3 people that are working on that case for you. It's really, is there a particularly sociable chair? Is there a particularly aggressive and partisan state-appointed arbitrator? These kind of inter-arbitrator dynamics between the 3, and horse trading that happens sort of between the 3 as well, produce sort of a fairly inconsistent body of legal reasoning that, again, presents, it's not great for states, but it's also not great for investors. I mean, there's not a lot of predictability in terms of what you're going to see happen, which, I mean, is one reason why political scientists think there's sort of an excessive amount of litigation, because the parties ex ante can't know at all like how the case is going to turn out. So, and I think that's, Luis, I think that's part of the appeal of the institutional bench, right? You at least sort of formalize it a little bit, make it a little bit less, give states a little bit greater say in appointing who gets on the investment court. That's the appeal of the system. But again, that system, I think, works best in a domestic context where you have checks and balances and where judges that go completely off the rails can be impeached. And that there's sort of this constitutional and political dialogue that's happening within the country. I don't know that you're going to get that at the international level, which is why I don't think that solution, to my mind, solves the sort of bigger problems. Cecilia, please. Ambassador from Argentina. Former.
Thank you. Thank you very much for the presentation, which I really think it's very timely and necessary. And yes, having represented Argentina in this process, it was really tough in many ways. And as you were saying, Haley, it was always striking to see that the sovereign was in the same field than the private corporation. But in fact, it was never a playing field. It was really always very much leveled in favor of the companies. And one thing that I would like to ask you about is that there was another third actor many times present, though maybe not so visibly in the room, which was the country where that corporation was based. And diplomatic protection was always very much happening. This is the conclusion that we got, very much happening at the same time. So it was like Argentina, which is a medium-sized country that maybe had the resources to pay for the lawyers, but not the strength for many things, fighting not only to a huge corporation, but many times also fighting implicitly with the country that hosts that corporation. I wonder if you have something to say about that. And then to Todd, I very much agree that the system needs to be fixed in many, many ways. And two questions. The first one is, what ideas you have in relation with the huge stock of treaties that exist? In the case of Argentina, the government that I represented many times thought about denouncing, renegotiating, something with them. But the specific clause that is in many of the treaties that Argentina has of ultra activity, I mean, the fact that even if you denounce the treaty, it will give the protection to the companies for 10, 15, 20 years, was always very complicated, because there's a lot of incentives for the companies to sue you the day after you denounce the things, just because they don't know what's going to happen in the next years. So that was always a very serious limit to the mere possibility of thinking of renegotiating or denouncing or really replacing the system with a better one. Thank you.
Todd, why don't you answer the second question first, and then.
So that is the structural genius of investor-state dispute settlement, which is that you have, and as I presented at APSA that I referenced in the Politico story, you have a system with multilateral rules, bilateral rules, so sort of two big multilateral treaties, 3,200 bilateral treaties, national court enforcement procedures that vary country by country, and ad hoc arbitration tribunals that decide what the law is going to mean in a given case at hand. So it diffuses the decision-making power throughout a lot of decision makers, which makes it really hard for a country acting alone to make change to their own treaties, much less sort of the universe of treaties that are out there. So it's a very ingenious governance system, because it is very difficult to exit for that reason. And that's some of the reason why you've seen countries in Latin America that have begun the denunciation process, like Bolivia and Ecuador. They go down the road, they denounce a few treaties, and then they sort of realize this is going to be really hard. And we're getting major hits in the international financial press. We're getting banks worrying. We're getting diplomatic pressure from the US. You start to go down that road, and then you realize that the sovereignty benefit is going to be quite low if the treaty has an overhang period of 10, 15 years, relative to the cost, which are going to be immediate, and which with the regime in place at the time is going to feel. So the regime in place at the time is not going to see the benefit. They're going to only see the cost. So it's a very ingenious system in that respect, which is why I think leadership has to come from the US. I don't think it's fair to ask developing countries to stand in the firing line on this stuff alone. I think you have to have the US sort of go out there and say, hey, look, there was a lot of unanticipated consequences to this treaty system, including from our own negotiators' perspective. Let's have a rethink. So I think that US leadership, and as well as European leadership, is very important. And I think just one quick note on the previous point that you made about sort of gunboat diplomacy. I mean, I think that that's like one, from an arbitrator's perspective, that's one of the main benefits to the system, is that you apparently do away with the system where states are sending in the navies. Instead, we're just having a polite tribunal discussion between three arbitrators. Jeff Gertz from Brookings, who's here in the audience, has just finished a major study of this, and he actually finds that the gunboat diplomacy never goes away. Even alongside this sort of legal system and the legal maneuverings, you have the State Department, you have other countries' foreign ministries continuing to use pressure, and they've mined an incredible resource, the WikiLeaks disclosures, to show at the same time as the company was litigating the case in the arbitration tribunal, you had the government representing the company's interests bilaterally. So the political pressure never really disappears.
Yep, and that's a great point. That's the everyone I spoke to, and I did a lot of reporting in Argentina. I was there for 2 weeks, and everyone I spoke to said the idea that the US government wasn't entirely involved in this is just that's just a myth. I mean, it is theoretically a private investor or corporation that is entirely separate from the government. I mean, that's the idea, that you create a diplomatic non-militarized zone, I guess, where you kind of create the separation, but that separation doesn't actually exist. And in off-the-record conversations with people at state, they'll say that much. They're following these cases very, very closely. They're involved. They won't weigh in. They'll weigh in on cases and say, this is how we interpret this language in our treaty. But they're there hanging around the background. They're definitely in the wings, and it definitely creates political strife. If you don't think there was political strife between the U.S. and Argentina over corporate losses after the financial crisis, then you're living in an alternate universe.
Sir, here. Sorry, second row, sir.
Will Amatruda, you've raised the issues of the financial incentive to litigate these cases because of the potential payoff, and you've also raised the issue of suing for lost profits. I'd like to deal with the second one first because my question, I think, can be answered with a yes or a no. I went to a presentation this morning at AEI dealing exclusively with TPP, not with these agreements in general. And in response to a question, the U.S. Trade Representative of Froman said, well, yes, some of these earlier agreements you could sue for lost profits, but not in TPP. Is he right or is he wrong? That's the yes or no. With regard to the incentive to sue, in federal civil litigation, there's the concept of the frivolous lawsuit, and lawyers can be sanctioned under Rule 11 for filing them. Presumably, they can be disbarred from federal courts as a result. Now, I don't know how you could apply something analogous to that in these forums, but I throw the idea out as something to consider.
I asked Froman the exact same question. I asked Michael Froman, the U.S. Trade Representative, the exact same question about whether it's possible to continue to sue for lost profits. And, I mean, it should be a yes or no question, but it's an arbitration tribunal. So you can't. So a corporation can't challenge the U.S. under the rules as they're written in the TPP and say, you owe us for our lost profits. They can't put it that way. But they can say, your nation, in deciding to cancel our project, violated my expectations of a fair and equitable treatment in your country. And in response to that, I would like this much as an award. I mean, that's a distinction, kind of without a difference. But the answer is basically yes. You can't have the idea of one's legitimate expectations of how they will be treated in a foreign country is very much enshrined in the way that ISDS chapters have been written and continue to go forward. And this circles back to Luis's question, which I never answered, about the TPP being tweaked and improved. And that's the whole idea that Froman talks about and that President Obama talks about. They say, all these problems that you're seeing with ISDS in the past, the reason why we're getting sued by TransCanada through ISDS under NAFTA is because those old versions of ISDS aren't as good as the current version. They say that they've fixed the problems, that they've tightened up those loopholes. But it all comes down to, and this is where the structural issues just become entirely important, that A, you still have almost all the same language in there. You still have the national obligation to provide fair and equitable treatment. You still have a national obligation to provide fair and full protection or something like that. There's all these very broad umbrella terms. And all of those things, and I'm sure half this room are lawyers because this is Washington, D.C., if you leave what it means to treat someone fairly up to 3 private individuals in a room, they're going to come up with different interpretations of that. And that, and so in that case, there's a lot of situations where corporations are still bringing suits under fairly new bilateral investment treaties and certainly investment chapters that have been rewritten and tweaked as our template was in 2004 and again in 2006, and then I think in 2014. There have been all these improvements to the U.S. bilateral investment treaty, and we continue, or to the template that we use in negotiating future treaties. And I think it's just really hard to make those impenetrable to things like violations of legitimate expectations and claims to future profits. So that's a long way around. But there was another question there, wasn't there? Or did I answer it?
I think maybe on the question of sort of lost future profits. Yeah.
Right.
Potential payoff, and what do you do to discourage frivolous litigation?
Well, they've taken some steps to create, and El Salvador's benefited from this, as of other countries, in some of the more recent treaties, to allow for early dismissal procedures for a claim that's totally without merit. However, and I think, I went through the TPP investment chapter on the day that it was released to the public. And you kind of go through, and as happens with these things, there's a few things that are better, there's a few things that are worse. And I was looking at some of the things that were better. I was almost about to get excited about it. I was kind of like, oh yeah, there's going to be some awesome things in the TPP. But then I looked at another provision, and basically they're not replacing the TPP. The TPP is not going to replace all of the bilateral agreements that already exist between all of the member countries. So you have, NAFTA, the NAFTA template, coexisting with the TPP template. You have all of these templates existing on top of one another. So the investor gets to choose which treaties they'd like to litigate under, and there's a lot of other ways that they can do treaty shopping. So that's why treaty by treaty improvements don't do a lot for better protection of the state interest, in my view.
Could you pinpoint, or at least speculate as to who and where in the government would be responsible for carrying the ball to move forward on any of the proposals for change that you think are realistic in the next administration? My name is Paul Booth. Are we talking about the Office of Legal Counsel of the State Department? Are we talking about the USTR? Are we talking about Commerce Department? Who is it? The United States Congress that has to do the thing, some or all of the things that you're talking about? Where does change come from? Assuming that there's going to be a change agenda, how does it get driven? Who leads it?
You go
Where
ahead.
does change come from?
Well,
Yes or no?
it would, in terms of changing the language in treaties itself, in terms of removing or replacing ISDS, that falls to the U.S. Trade Representative's office now, which is under the direct auspices of the executive. So you would have, and state, state matters too. If you had someone at, the future Secretary of State and the future U.S. Trade Representative, both of whom were appointed by a president who wanted to see a substantial shift in the way ISDS works, you would see major change coming from the U.S.
And what would they have to do first on the 21st of January?
Well, you have
I
your
think they should have an executive order amending the Federal Arbitration Act, then get that through Congress, and then gradually build up support for a multilateral treaty rethink. I think that's how you do it. But I think that there's some deep problems in the structure and the incentives of bureaucratic organization as we have it now. I question whether the U.S. Trade Representative's office would ever be capable of carrying out a mandate that wasn't to get as many treaties done as possible. So we've in my fast track book, which was referenced earlier, there's been a lot of different ways that the U.S. government has organized its trade making responsibility over the years. Sometimes Congress has played a greater role. In the past, state has played a greater role. The administration spends a lot of time saying that TPP is this great foreign policy idea. Well, then maybe if it's purely foreign policy and we've given up on this doing anything from domestic manufacturing, maybe it belongs in the State Department. You have to kind of ask, what are the goals of the policy, and then sort of what is the bureaucratic structure that's going to be likeliest to deliver change. I'm cautiously optimistic. I think that there's an opening with the next administration to do something different. There always is, but I think this this is, and you've had both candidates campaigning on a change of vision. So I think that that's kind of a unique, since the 19th century, I don't think we've seen such alignment from both parties. Be a little skeptical of these things.
Yeah, I mean, I am skeptical of any substantial change coming on that front. You are seeing, right? I mean, there's two ways to reform deeply entrenched systems that exist. There are more than two ways, but let's just go with two. One is the embed in the systems themselves and to attempt to reform from within, and the second is to the ramparts, and just like burn it down and build something new. And you've seen both reactions when it comes to ISDS. Certainly abroad. I mean, Venezuela and Ecuador have attempted to have full-scale withdrawals from ICSID, from the World Bank structure that oversees these ISDS claims. Venezuela, and South Africa is waiting for a lot of their treaties to expire so that they can renegotiate them in that way. And I spoke to several people in their government who said, we're pushing just to not even have ISDS at all. Brazil has never signed an agreement that includes ISDS. So the US would get a whole lot of pushback. It would be very difficult to do without losing support for any future agreement from the business community. I mean, any treaty that you pass that does not include ISDS or that substantially unwinds the power of this judicial body would get enormous pushback from the Chamber of Commerce, from the business roundtable, from all of these organizations, from major corporations that for whom this is a major and powerful tool. So insofar as the US can pass a treaty that doesn't have the support of the International Chamber of Commerce, yeah, it has a possibility.
Other questions? Here, red tie.
Hi, Dan Maurer with the Communication Workers. I see a few people in the room who I know spend quite a bit of time down at USTR. I'd hazard to guess that there's a few more I don't know who do so also. And the sort of dynamic that you talked about, Todd, with them sort of feeling okay with the status quo and sort of dismissing out of hand some of the problems, even the more egregious problems that Haley talked about in terms of arbiter contract conflicts of interest or sort of vastly expanded interpretations of wording, that happens, but it's also, it seems to me, it's much more sort of trying to power through and entrench this further, and just in a couple ways. Like one is, as I'm, in chorus, it set the possibility that if an appellate system was established for ISDS, we'd join. Now that's gotten walked back in the TPP. I think it's probably fair to guess that's the US's ask. It's also true that we're trying to set up an ISDS framework with Europe, where I had a debate with Ambassador O'Sullivan from the EU about this, and I said, well, we have a functioning court system, so do you. Why do we need this? And he said, well, what if the United States starts trying to steal European companies, which seems like that's a bigger problem, and that's not really a credible argument to me, right? That's a much bigger problem than a trade agreement. And then meanwhile, we're trying to power through with an agreement establishing ISDS with China, where state-owned enterprises would get this. And so when they're sort of trying to just like lunge through in the face of popular opposition, it seems to me that really, and I guess Haley sort of just got at this, but the problem is not so much about the existing laws, right? I mean, that's the narrow problem. But the problem is about the power in terms of how this is getting established, right? And that seems like strikes me as the main hurdle to your proposal for reform, because if suddenly you can get labor rights and environmental rights and public health rights and all sorts of things, the people who have the power to do this don't have an interest in that.
Yeah, I mean, just to respond to your very first sentence too, I spoke to a lot of people at USTR for this book, including people who, I mean, most of the people I don't quote, they're not speaking on the record. People who were involved in the negotiating room for ISDS, for the TPP, and the TTIP, the U.S.-European agreement. And I think that they're actually not satisfied with the status quo, which is interesting. Where they're not satisfied with the status quo as it's in the books now, where they actually see major problems with the U.S. template for ISDS that existed in the BIT 4 or 5 years ago. And that's because of challenges to the U.S. and because of challenges to other countries, where they'll see this very loose language being used in ways that they say, like, we don't want that used against us in that way. And so they'll attempt, as I said, to, like, tighten up these little holes in the knitting. The issue there is one that you touch on at the end, where it's basically like a difference in strategy. They believe that they can write this document in such a way that it is leak-proof. And the other folks who would prefer a different system, or as Todd is advocating for, rewriting the rules from the ground up, is just don't believe that you can do anything to that document. It doesn't matter how many hours you spend with it. The problem is that then it is interpreted by 3 private individuals in a room by themselves. That's the problem. And the problem is that it puts corporate interests on the same playing field, whether or not it's tilted with a sovereign nation. I mean, these are their problem. It's an argument over whether or not it's a structural issue or whether the language is at fault. And I think that's a fissure that runs absolutely down the middle of the ISDS debate right now.
And I mean, as to the power argument, I mean, that's key, right? I think that the current incentives at USTR are to, it goes in the opposite of trying to build better legitimacy for these agreements. I can't think, if the problem politically right now is a lack of support for trade agreements, I can't think of a worse way to build legitimacy for it than trying to ram the TPP through in the lame duck. I mean, that just seems completely backwards. And I think that's part of the problem. I mean, so USTR doesn't have an incentive to take their arguments to the US public and get agreement, get consensus or not, but figure it out. Instead, it's kind of trying to work back channels. And I mean, I got a book, I highly recommend it, from 1945, The United States and the World Court. This documents 50 years culminating in the Roosevelt administration, where FDR went out and made the case for progressive internationalism and built support by getting on the radio and going out and giving speeches, and not relying on lawyers to try to solve the world's hairiest diplomatic and business problems. It's a different model, and I mean, it's a long-term thing, but I think if we can start now, if we can learn to sort of build on some of the progress that we've made in the recent years. And I think with that, we are running out of time. Do you have any last things you want to say?
Yes, I mean, just one quick comment towards the end, and I said this in the beginning, but we are at just such an interesting inflection point in our international moment right now that I want there to be and then we have so many like influential people in the room, people who write, other people listen to what you write, and people who speak and listen to what you say. So think about what the role is for international law and what those structures look like. Because you hear this coming out of the progressive left will say, they're against trade agreements and against what they see as this corporate overlord that's determining international agreements, but then they're 100% in favor of the Paris Climate Accords. And what we need to talk about is how we solve global problems and how we create institutions that are reflective of the people and the agendas that we actually want to promote. So all of these trade agreements are so complex now, and they involve everything from these like, strange supranational tribunals that in my opinion are flawed structurally, and also all of this other stuff that it's just there. I don't think that we live in a simple world anymore where you can just be opposed to international law or be opposed to these international institutions. What we need is to come together and basically create institutions that serve the interests that we want them to serve.
Thank you. Please join me in congratulating her.
Thank you.
We have books available in the outside, I believe, and please mix and mingle and buy some books and buy one for your grandmas.
Thank you so much for coming, everybody, and thank you, Todd, for being here.
Say they play it, watch it, then press rewind.